Hey folks, welcome to Abrenio Law's podcast, where we talk about Virginia law, policy, and other important things in Virginia. I'm host James Abrenio, and on today's show, I've got a very interesting, important guest, Maggy Vaughn of the Law Office of Maggy Vaughn. And so she was kind enough to send me her nice resume. So just a little bit of background about her. And just before we begin there, what I wanted to do was have her come on and talk about civil detention orders. Essentially, when somebody's suffering from a mental health issue, they are in a position where they're going to be held because of that mental health issue. We do a lot of criminal justice reform stuff on here, but on the flip side, on the civil side, I figured Maggy's very experienced in that, and I wanted to have her come on and talk about her perspective. Just a little bit about her. She's got a bachelor's in government and international politics from George Mason here in Northern Virginia. She graduated from law school at Elon University, which is a great law school. As I said before, she owns her own law firm. She's a member of the American Academy of Adoption and Assisted Reproduction Attorneys. So in addition to civil commitment hearings, she also does a lot of adoption work. So if you're looking for help there, she's my go-to person. She's the secretary for Virginia Lawyers for Children. She serves as a guardian ad litem. She's a former adjunct professor at the Antonin Scalia School of Law Mental Health Clinic here also in Northern Virginia. And she's represented petitioners at the commitment hearings for 4 years. And she's conducted over 2,000 hearings. So a lot of experience. She knows what she's doing. So Maggy, thanks a lot for coming today.
Thank you for having me.
Yeah, and I know it's been a little bit of a logistical issue. So Maggy was kind enough. I was having some software issues, so she was kind of to be flexible and get here on Zoom with me. So, and by the way, Maggy, I wanted to compliment you on so many books that you have.
It's to detract from the fact that I don't really know what I'm talking about.
No. I like to have people on here that's smarter than me, so thank you for joining us. So I figured the best way to start this off is talk about your role, and I understand it's changed recently, but your role in civil commitment hearing. Just talk about generally, where do you come into play, broadly speaking?
So I was representing petitioners at mental health commitment hearings, and what that means is that those people have filed a petition in the general district court alleging that it's usually a family member, but sometimes it's professional staff, alleging that a respondent needs mental health treatment and that they have a mental illness, first of all, but also that they're a danger to themselves. So that they would be pretty far along in the process. I think by the time I was involved in that, they'd already had a TDO issued. We didn't get involved prior to that.
Yeah, and just before you go there, explain to the people watching this, what is a TDO?
So a TDO is a temporary detention order that is issued by a magistrate, and it's basically a legal mechanism for the police to transport you to the hospital. It's a little bit different from an ECO, although they have the same, burden of proof. An ECO is a little bit different. It's designed to transport that person to a mental health facility for assessment. So you can have a TDO without an ECO, but the ECO only gets you to the mental health facility, which in Fairfax County is the Community Services Board building, the Merrifield Center. So that's sort of the difference. Okay,
so the ECO gets you to Merrifield, and the TDO would get you into, the hospital. Okay. Now, as far as ECO or TDO, what is the family member alleging? What has to be found? And when a magistrate's looking at it, like, what is the standard? Is it beyond a reasonable doubt? Is it more likely than not?
So it's probable cause, basically, that they meet the criteria. And like I said, those criteria are the same for the hearing, for ECOs, and for TDOs, or they're just basically tweaked a little bit. But it's the Supreme Court requirement that's big here, in that we can't just detain people because they're mentally ill. There has to be some proof that they would be either a harm to themselves or to others, or that they lack the capacity to care for themselves such that they may be a danger to themselves. So that's the main crux of what we do, is that proof of that second part of the process. And that's not always true. You have other times where the mental illness part is in question, but most of the time is this person meeting this constitutional threshold where we can hold them against their will?
And is the process different whether or not you're an adult versus a minor? Is there a different way that's treated?
So yes and no. Obviously, minors are always different with this particular process. So if you were to issue like as a family member, an ECO or a TDO, it would look very similar. I would say the big difference is that juveniles under 14 can be admitted just with a parent over their objection. Once a juvenile is 14, they have a right to participate in the hearing, and they can object to their own treatment at a hospital. Also, it's a little different. I would say the one other way that it's different that people don't know is that it's sort of expected that the parent would be the petitioner. And in fact, in the code, it references that you really can't have someone be the petitioner for a child to get mental health treatment without the parents being on board, unless that child meets basically a higher threshold in order to issue it that way. So it's really designed to sort of have the family be part of the treatment process. And the other thing is that juveniles are allowed to volunteer, and the way that their voluntary process looks is a little bit different than adults, in that we dismiss the petition entirely. So you still lose your right to purchase or possess a firearm, which is a little unusual because you're withdrawing a petition, yet you still lose that right. And I'm still not, I think there's some work to be done with that regard, but otherwise the standard of proof is similar to an adult.
Now, you said in the juvenile setting, it's typically the parents, or that's the way it's designed to be. Is there any type of relationship requirement when it comes to adults? Can it just be, hey, I see a guy on the side of the road and I have concerns?
So it's not necessarily a relationship that they have to have, but they do have to be an interested person. So they have to have some kind of a relationship to that person. You're right. You can't just pull someone in off the side of the road and say, this person needs help. But I will say I have actually seen cases like that. For example, people walking down the side of the road who are in danger. Maybe they're on the beltway or somewhere dangerous where a bystander just comes by and sees them. So their special relationship really at that point is that they are a witness to some of the behavior. So it doesn't have to be that you have this great prior relationship, but you're absolutely right. You can't just be a stranger walking in.
Well, but it can be tenuous. I mean, is the relationship really just I have foundational information that would demonstrate probable cause that this person's a threat to himself, or others, or herself and others?
Well, so if that was, what I would say is that usually what they do is they try to find a petitioner that is either a family member or a law enforcement officer. So if in that example I gave, it's most likely that a law enforcement officer would arrive on the scene, and they don't have to have a magistrate issue an ECO. They can issue what's called an emergency ECO, which allows them to take someone into custody. Again, just the ECO is getting them to that evaluation. And so they could take them into custody, get them to that evaluation, and at that point they would likely become the petitioner, and the other person who saw them on the side of the road would be a witness. So that's most likely how that would go. But let's say everybody else was out of the picture. That Good Samaritan could still go to that magistrate and make that argument that I am a member of this community and I'm seeing something happen and nothing's occurring and I need to have this petition issued. It would be up to the magistrate at that point.
And when we talk about magistrate, is the magistrate the same person that's making the same determinations whether or not a criminal charge should issue, or is there a specialized type of magistrate?
Nope. So we have specialized special justices that preside over the actual hearings.
Mm.
The people who are making the decisions in terms of what is an ECO, what is a TDO, and what is really whether or not those standards are met is the magistrate, just the regular Fairfax magistrate.
And I actually meant to back us up a little bit when we're talking about Merrifield. I think that's a great resource that a lot of community members may not know about. Can you just briefly give, and that could be a whole 10 shows in itself, but just a general overview of what Merrifield is?
Yes. So we are so fortunate in Fairfax County to have this as a resource. The Merrifield Center is staffed 24 hours with not only folks who can do these evaluations, but also a psychiatrist. And I think, one of the things I want to emphasize too when talking to people who are, have family members who are maybe going to be in crisis is it's really important to surround yourself with a team and to have some people who are going to, let's say, accept your buy-in. So help that person sort of buy into the system. So we have people come in all the time who are there for either an emergency ECO, they're seen doing something dangerous, they're taken into custody, or their family brings them in. And, we're able to sit down with them and say, look, you need to take your medication. And when you take your medication, you're fine. And so a lot of those compliance issues can be solved immediately because there's an actual psychiatrist on site. I think other places it becomes, I'm in crisis, I need an adjustment to my meds, or I need a refill, but my psychiatrist isn't here, or they're not answering the phone, or I can't get a hold of them, and your situation can get far more acute. So I would say go early, go often to Merrifield, because if you don't need to be there, they will tell you you don't need to be there and connect you with services that you can access, not on an emergency basis. So there's really no downside. They're very nice folks and they're there to help, and they know a lot about the other resources we have within the county.
And not to stick to Merrifield too much, but do you have to have any type of financial need in order to get those resources, or just have to be a county resident, or can you just be anybody?
So you do need to be a county resident in order to access more long-term services. And I think really to get an evaluation with an ECO, you need to have venue over the ECO, which is a little bit more complicated of a concept. But otherwise, so don't be afraid to go if you're not a resident. If it's an emergency, I would say, but call first. But otherwise, you are really supposed to be a resident, and the services that they provide are provided on a sliding scale. So if you have insurance, they'll bill your insurance first, and then you would supplement whatever hasn't been supplemented, but it is on an income or a sliding scale for folks. So that's a good resource if people are having trouble, especially now with unemployment being how it is. We still need to treat our mental health.
Now, a lot of times, at least from my observation, and I defend a lot of protective order cases, so and I do criminal defense, so I'm a bit biased, and I acknowledge that. But many times I'll see protective order cases being brought where the standard is you have to demonstrate that there was a family abuse, or I think there's now, it actually extends to non-family members. So there has to be some type of abuse and immediate need to protect the petitioner from the respondent. Do you see a lot of situations where it's and what I was going to say is it ends up, in my view, not being an actual need for a protective order. It probably was a better position for them to have went and tried to get help on the civil side as far as ECO or TDO. How would you, and this is kind of a broad question, maybe unfair question, but like when you have a situation where you have a family member or a loved one that they probably need mental health care, you're not sure that they're a danger to you individually, maybe not. How do you distinguish between going the TDO route versus the protective order route? And do you do protective order? I don't know if I asked you that. Do you do protective orders to kind of give us a better view, which is better, and kind of how that works through the system?
I would say the hard part about my job, the challenging part about it, was that I was involved in these people's lives for this brief kind of snapshot. And so I wasn't as involved in sort of the follow-up to all of this. But what I would say is that when you have family members, I would say, you don't want your family member to go to the hospital. It's not that it's a bad place. I still have friends who work there and they're lovely people, and it's just not something that you need unless you're very, very acute, and it can be expensive, and it's for a certain population. So I would say if you feel like you're getting to the point where you think someone may need to be hospitalized, that first step is going to be trying to get that person to Merrifield to get connected with resources. And that is really the most important thing that you can do as a family member, is to, make sure that your family member is complying with medication, seeing doctors and therapists when they're supposed to, and having that freedom also to let them know that if they're having a side effect with a medication, that's okay. We can find a different medication. So I would just say anything that you can do to sort of assemble that team, and the people at Merrifield can direct you to therapists and psychologists if that's what you need. That's going to be the most important thing in terms of, because the goal is really to never ever see me unless we go to the library, because you just want to keep those people out of the hospital, and we want to keep people from being that acute.
And by the way, which hospital are we talking about? Is there multiple hospitals in Virginia or in Fairfax, or we're talking about?
Yeah, there are. So the 4 hospitals that we hold hearings at in Fairfax County are Dominion, Northern Virginia Mental Health Institute, Fairfax Inova, and Mount Vernon Inova.
What determines which hospital, if somebody gets held, what are the factors determine? Is it literally just where they live, or are there particular hospitals that suit particular diagnoses? How does that work?
So that is a great question, actually, and that's something that they've done a lot of work on in the last several years. I know there was a state senator, Mr. Deeds, whose son encountered a great tragedy after not having a bed available, which they found out there may have been one later. That's a whole other conversation. But the good that came out of that was that they created this statewide registry of beds. And so the great thing about that is, sometimes we have like a full moon, or so, I don't even know what it is, but you're really, really busy. And so I think in past times, you wouldn't have access to those resources, where now, because we have this statewide registry, you can get a bed when maybe you wouldn't have been able to otherwise. But the downside to that is that we only go to those 4 hospitals, but it's possible for a Fairfax County resident to travel to a facility, in Newport News, in Williamsburg, Richmond, which we know that makes it very hard for people to engage in their care and have their families nearby, which can be very important. So we try to keep people first locally if we at all possibly can. And then we have Fairfax County has some amazing bed finders who do amazing hard work to try to just get everybody where they need to be. Sometimes we have to have people on medical floors because they have underlying medical issues, so that will dictate if after we hold the hearing, there's another chance you may be moved again. Like if you don't have insurance, we try to get you to the state hospital just due to cost reasons and keeping.
And is that a Western State or one of those facilities when you say state hospital?
Well, so Northern Virginia Mental Health Institute is the state hospital here.
Okay. How is that different from Western State and Eastern State and all that? Or is that just the different name it goes by now?
I mean, yeah, so Western State has a different population. They're mostly NGRI, or not guilty by reason of insanity, patients. And I actually have had people say wonderful things about Western State. That's actually not all that they do, but the people who come back say, I was looking for treatment for years. I don't know what happened, but Western State, got this combination of drugs that works. So I do hear good things about that. They are all run by the Virginia state government. So that's basically all they have in common. And Northern Virginia Mental Health will have some inmates, but they're inmates from a jail and not a prison, if that makes sense.
Yes. Now, what do you say to the family member that is worried about somebody, but they're also concerned about the stigma related to trying to hospitalize somebody in those records and whether or not that creates employment issues and, the ability to get loans and all those other tangential effects when it comes to seeking essentially forced medical care for somebody?
That is a great question. And I think especially in this area is a great question because we have so many people who have security clearances or have some sort of, oversight of their backgrounds. And every time I learn those rules or figure out what they are, they change on me. Yeah. So I always tell people you need to sort of ask someone about that side of it. But I can tell you that the records are all completely confidential. No one can get a copy of the court order except for the respondent. And we really, all of your records are kept confidential. They're protected by HIPAA. We do our best. I mean, the hearings are open to the public.
Are they? Wow. Okay.
But we don't have a lot of public attendees. I think because we move from hospital to hospital, it would be a hard docket to track. So, yeah.
I find that odd that those are open to the public. Why has anybody ever tried to make those confidential? I mean, that to me that would be like the most sensitive. Right.
Well, they're confidential in the case of a minor, but they're not confidential proceedings. They're open to the public.
Have you ever? Sorry.
I said I don't know the origin of that, but I agree with you. That would seem to be a bit of a contradiction.
Have you ever seen anybody make an effort to make it confidential? Like, so you'll see it sometimes in criminal cases, you'll try to have a gag order entered or something like that. Have you ever seen an effort to try to shield that from the public?
No, just because we pretty much rely on, I mean, I guess they could motion for a closed courtroom or something like that. I've never encountered that. Usually what we do is we introduce everybody in the room. So there are people in the room who aren't attorneys, but they're mental health providers. And usually when people see, okay, well, everyone here is associated with the court, our professional ethics prevent us from saying anything. So it's really just if there's a random bystander who comes in, and that's fairly rare, I would say.
In a moment, I'm going to kind of ask you more specifics about what happens at the hearing, and I'll walk you through that. But I can't help, as defense counsel and kind of being involved in, the mental health stuff, at least tangentially. One of the concerns that I hear a lot and that makes a lot of sense to me is it sounds like TDOs or ECOs, at least by the statute, currently has to be served by law enforcement. First of all, is that right? And second of all, have you seen complications on your side when it comes to that issue of having law enforcement involved on the front end of things?
Yes.
And also, sorry, let me add one more compound question to that. Are law enforcement officers to serve these TDOs, are they required to have any additional training that is an average?
So that is a great question, and that is definitely something that is a difficult issue. You can have what we call alternate transportation providers, which can be someone like your family member or a doctor, a therapist, someone like that. But the magistrate has to authorize that. And so and argue that they are willing and able to transport this person to the hospital. It's rare. I didn't see it much on the TDO side. I mean, sometimes if you have a juvenile or something like that, or a case where someone is has some symptoms that are tied up with feelings around law enforcement. So you could have some paranoia or some delusional belief around that. So I've seen it done in those cases. I think it's not something that, I don't want to say people are hesitant to do, but you don't want, if someone is so dangerous that you're saying they need to go to the hospital, the thought is that probably they need a little bit of help to get there.
Yeah.
And I think that really oversimplifies the complexity of mental illness and how different symptoms manifest. So there is that mechanism there. And so I guess that's what I would say too, is if you're trying to advocate for a family member, if it's possible, if you are having to seek an ECO, to ask for that alternative transportation. And you can also ask for that at the end of the commitment hearing to the special justice. And he has to inquire to the independent evaluator as to whether or not that, that evaluator believes it's in that person's best interest. So it's something that needs some work. But I'm also sensitive to the fact that, magistrates are getting this information. So how do I put this delicately? Sometimes people in crisis, as we all know, are not the most accurate or, tellers of a story. So sometimes things aren't necessarily coming out as linearly as you would like. Often people have, mental health symptoms of their own, or they haven't slept in 3 days because they've been trying to assist their family member, or they're just sort of at the end of their rope. And so that magistrate is getting that information, trying to parse that out, make sure that it meets the standard, figure out if that person needs to be hospitalized. And it's just a lot to ask that magistrate to also make an evaluation of, is this person safe enough to be in a car? It's definitely an issue that needs some work. I don't know how we get there, but that's definitely the two sides of the coin that have to be balanced. And I think your other question was about training.
Yeah. Yes.
So,
yes.
Go ahead.
Sorry, I cut you off. You were getting ready to do.
I don't think you need special training to just do the transport.
Mm-hmm. Sorry, you're breaking up a little bit. Can you still hear me?
Typically, the person who does the transport, and this isn't. Hello?
Yes. Let's give it a second to pause. Okay. Can you hear me?
Yes.
Okay. All right. I think you're back. Okay. You were saying you don't think they need training, but.
I'm actually not sure. I know that we do have specialized officers who are trained in mental health, who are great. But sometimes it's just the officer who comes in. So for example, the example of the woman walking down the road, if that police officer just stops, he is responsible for transporting her all the way to the hospital. And that trip includes a medical clearance. So we really do put a lot of work on police officers in terms of the responsibility for transporting these folks. So I would say it probably should be someone with some specialized training, but sometimes because that officer has to really stay with them the entire time, it can just be whomever encountered them in the community.
And I appreciate that. And it kind of goes to something that I think about a lot. And some people may see this as like anti-law enforcement, but I think a lot of times we're asking law enforcement to do things that we shouldn't be asking them to do, especially when it's kind of a rush. You don't have a CIT trained officer, a mental health trained officer, and you're like, look, we got to call in, you got to go do this. and we're not giving them the tools they need. We're asking them to do a job that they're not trained to do, and just the inherent uncertainty is whenever you're going to a mental health crisis as to what's going on. I think, and my point when I say this is when whoever's watching this video, I don't want this to be seen as critical to law enforcement. In a lot of ways, I think it's a failure of our own system to not give them the tools they need, or to provide an individual that may not be a law enforcement officer that is able to serve this role. But I appreciate that. And like I said, it's not critical of them individually, it's critical of the system. So.
I honestly, I think it's not critical at all. My point in saying that actually is just exactly what you were saying, where I understand the safety and the liability of having the officer with them, but what it does is it creates a place that it's a lot easier to just drop somebody off at the jail than to track their treatment and be with them for as long as 8 hours while you're trying to get everything done. And the number of police officers that I encountered while doing this work who came off of night shift, had been awake for 24 hours, got in a fight with their wife about the daycare plans, just to make sure that people got to the hospital and not jail. There are, heroes in our uniforms.
Yeah.
So that's really the point I was trying to make, is it is easier to do that. And so every officer that came through, I was like, this is incredible that you're willing to make this jump like this and buy in. So that's a really positive thing.
And this sad thing, I've dealt with one or two cases where simply because Merrifield wasn't available, they were going to do the diversion first thing, where instead of they divert to Merrifield rather than arrest, but simply because whatever reason the hours wasn't working or they didn't have availability, they then said, all right, well, we've got to charge them with a felony assault on law enforcement officer and assault, and all these things. I don't blame law enforcement. It's just it's a failure of us all in a lot of ways. But that is neither here nor there, I guess. So, and you were getting ready to say something. I didn't mean to cut you off.
Oh no.
Okay.
No,
so let's talk a little bit more specifically about the hearing itself. And so, first of all, where do these hearings actually take place?
So they take place at the physical hospital, and so that's what the participants do. They drive from hospital to hospital. It's a little bit frustrating, I will say, sometimes, because the hearing can take a very short amount of time, or it can take a very long amount of time. And so sometimes we're running a little bit behind.
Yeah.
So that can be hard for family members. But I would say, if you're, I guess I'm asking a question. I'm answering a question you didn't ask, but the most important thing I would say for family members to have and to bring with them to the actual hearing is, I think it's important to write some kind of a narrative or a letter that outlines the symptoms that you have seen, any past care that the individual has gotten, any person who has seen or evaluated that individual so that they can coordinate care. And the first thing they're going to tell you is, we can't talk to you. This is the hospital. We can't talk to you. You need to have a release signed in order for us to talk to you. And that's true, but you as the family member can still talk to the doctor. And so I always think it's a great idea to try to get something in writing, because it has to go on the chart. And then instead of having to coordinate 10 people to get the right answer, or call you or call this person, it's just right there on the chart. Oh, look, he had a reaction to this medication. Let's skip that and get it moving more quickly. The other thing I think is important is just that proof side of it too, where you getting something in writing where you can say, this is where I've seen him be a danger to himself, or this is where he lacks the capacity to care for himself in a way that, or him or herself in a way that may cause him harm. So that's, I think, is the fact finding is the most important thing, because you really are that conduit of knowledge. And if the other person is too acute to give the doctor good information, which is very very common.
Now, who's making the decision? Can you talk about a little bit about that position? Like the judge, like what kind of judge, what kind of qualifications, that kind of thing.
Yeah, so the special justice is the one who makes the decision, and that has to be a person who is licensed to practice law or a retired judge, and they're appointed by the circuit court, the chief judge of the circuit court, for a period of 6 years. So in Fairfax, we have Bob Walker and Mark Bodner and Jose Union.
Okay. And as far as timing from the time, is there a period of time that they have to have the hearing within? Is there like a statutory speedy trial issue or that kind of thing? I'm trying to think of an analogous way to talk about it. But,
yeah, so it's not necessarily a speedy trial issue, which are always with the ECOs, the TDOs, and the eventual order. What you're fighting with is time, right? Because once those things expire, you're done. And like with an ECO, you have to wait 96 hours to obtain another ECO because people, were trying to get around that by just let's
go
file
back and back.
But you can't do that. So it's the same with the hearings where you're trying to get all of this, you're up against the clock. Fairfax County actually has their hearings within 48 hours. Wow. The code mandates that you hold them within 72. I think that Fairfax is the only jurisdiction that does 48. They had changed the statute a number of years ago to extend the time, and we just kept it at 48. But that does mean, if you have a family member who's committed, that you need to start getting your evidence together pretty quickly because you're going to have a hearing within 2 days unless it's a hospital or on a weekend.
Now, with these hearings, does the respondent have counsel? And what is your role, by the way? Specifically, are you prosecutor? Are you defending? How's that work?
So I would say Fairfax County has a county attorney who represents the Community Services Board.
Okay.
And they also represent petitioners if they don't have a conflict. So for example, if the Community Services Board says, I think this person should be in the hospital, but the petitioner says, I don't think they should be in the hospital, I want to withdraw. In that case, we wouldn't represent them because they have a conflict. But the respondent has counsel, and they're appointed almost immediately. People sign up for the week. And so they, like I said, we have the hearings within 48 hours. So they get out there pretty quickly to talk to their clients. And they represent their client at the hearing. The petitioner is usually represented by the county attorney. So it's not necessarily prosecuting, but it's definitely, your goal is to obtain the treatment that the Community Services Board believes you should, essentially.
And I'm a criminal defense attorney, so I'm a hammer, it's a nail, and that's I go for broke. Respondent counsel, it sounds like it's not really as necessarily a litigious oppositional representation. A lot of times, does the county attorney and respondent's attorney kind of agree, hey, this is what a good outcome is, and there's not a whole lot, or do they just present the evidence to the judge, not in a really argumentative way? How does that work?
Well, so what I would say is that the statute is written to, again, we always want to encourage voluntary outcomes. So the statute is written so that when you enter the hearing room, the first question basically everyone asks you is, or the special justice really, do you wish to volunteer? If the respondent agrees.
And what does volunteer mean, by the way? Let's be basic.
So if the respondent agrees to volunteer, it means that they'll be held in the hospital for a period of at least 72 hours, after which they have to give 48 hours of written notice before they leave the hospital. So they can stay, if they did their 72 hours and then immediately put in their notice, that would be a minimum of 5 days. If they decide they want to stay a little longer, sometimes people get in the hospital and they understand they need to be there and they want to kind of figure out where they need to go from there. They can stay as long as they like, but they still do have to give that 48 hours worth of notice. Your other alternative, if you don't volunteer, is you go to a hearing. And at the hearing, you can be sentenced to up to 30 days commitment in the hospital.
Sentence wouldn't be the right word, right?
Well, you can be committed to the hospital for up to 30 days.
Yeah.
But really, it's up to the doctor to release you. So I think they did a study. It was the average stay was like 5 days anyway, even if you're committed. But to the person who's sitting in that seat, it's 5 sounds a lot less than 30, right?
Yeah.
And so and people get frustrated sometimes with that on the petitioner side, because they say that's not enough time. And there's ways to sort of, start the process over again if needed. But on the respondent side, sometimes, really the respondent's counsel is saying, if I think he looks to see if he thinks I have a case or if the county has a case. And if they do, he's going to advise that person to volunteer for the 5 days. And sometimes that feels a little bit like a loss, I think, to the petitioner, but we always consider it a win because they are in the hospital where they can get treatment if they need it. And the hospital itself can actually re-petition if they think that person needs more time. But that it's comforting to know that the average stay really usually is 5 days, whether you're committed or whether you volunteer.
Now, during the hearings, are there rules of evidence, objections, hearsay stuff, all that? How does that work?
Yeah, it's definitely, it works and it doesn't. I can tell you, I had a hearing, and it's sort of a small cabal of lawyers that do these hearings. And then we travel, right, from hospital to hospital. So we're usually pretty cordial, I would say. And I had an attorney who I actually really enjoy practicing with her, but she made a hearsay objection about some of the records, the medical records. And in the statute, it says that it can be considered as evidence, but her argument is it still doesn't basically waive the hearsay. And so I basically had it that day. And I said, Your Honor, I'm asking for a recess to go down to the registrar's office and get a notarized, affidavit so that I can come back up. And is that what we all want? We all want to wait. And she was like, okay, fine. If that's what you want to do, you can have a recess. And he goes, you have 10 minutes. And I ran downstairs and I said, I need this notarized, or in 10 minutes, this case is getting dismissed. And it was, so there's definitely some back and forth like that between counsel, and it makes it fun.
Okay. Now, what are, besides, hey, you're going to be hospitalized for X amount of days, what other alternatives can the hearing officer issue?
So basically, you are, if you volunteer, then you don't have a hearing. If you go to a hearing, you can be involuntarily committed for up to 30 days. I will say the special justices are also known to not give someone the full 30 days. And so I would say that's another thing as a petitioner, is if you think they only need 15, that's something that you could ask the special justice for. So they could involuntarily commit them for any number of days, up to 30. The case could be dismissed on the merits. The petitioner can withdraw the petition. Or we have something called mandatory outpatient treatment, which is basically court-ordered outpatient treatment. So that means that those folks would leave the hospital and go back to Merrifield to get an MOT assessment. And for the next 90 days, they're under a court order to comply with whatever is recommended. And MOT, I think, has some provisions about medication that they don't have in the hospital. Because it's an agreement with the court, basically.
And just, I know we talked about it earlier, but we had a little bit kind of winding discussion. Just to clarify again, what exactly is the court, or not the court, the special justice, what finding must he make in order to hospitalize somebody? Like, what are the actual factors?
You have to prove that someone has a mental illness. And like I said, substance abuse can count towards that. And that there's a substantial likelihood in the near future that the person will cause physical harm to himself or to others, or that he will suffer serious harm due to his lack of capacity to protect himself from harm.
So that last one, will suffer, that sounds like kind of the most speculative one. Can you give us an example of what that means?
That's a really good point. So I suffer serious harm due to lack of capacity are things like, I would say the biggest example are people who have catatonia, which is when you're just sort of unable to respond.
Mm-hmm.
Which I didn't know until I did this job is actually an acute anxiety response. And so those people are treated with anti-anxiety meds, and eventually they'll kind of come out of it. But you can actually die from catatonia. But so those people are, they're unable to eat, they're unable to shower, they're unable to be engaging in conversation or advocate for their needs. So that's sort of like, I guess, the most severe example. We've had other cases where people have medical conditions that they're not treating. They may have a delusional belief that they don't have those conditions. And we always have discussion with the special justices about how severe does that have to be, right? So if someone has their diabetes a little bit out of control, but they're not in, ketoacidosis, they're not having those really severe consequences that we know can come yet. Is that person suffering serious harm right now? Do we know in the near future that they would be suffering serious harm? Well, I don't know. Sometimes the consequences of diabetes can take years to.
Yeah.
So is that, suffering? So you're right. The third one, it can be it sounds sort of wishy-washy, but the way that really I see it is some sort of, almost like a medical issue or a catatonia issue. It's not just this person can't manage their finances, or this person can't, parent. Like that's maybe some evidence of another factor, but not on its own.
And I apologize for the phone ring. Is there anything else about the process itself that, that I haven't thought to ask, that you wanted to make a point of, or some information that, if somebody's watching this, that, you always constantly are given advice about? It's really a broad-ended question, but any last tips and any other suggestions?
I guess I would just say, if you have family members who are suffering, I mean, the most important thing, as I said, is just to get a team. And even if, you can't get your family member to engage, go to therapy yourself. If you do whatever you need to do to try to have a situation where you have some support, because it's a difficult journey for the person involved, but it's also a really difficult journey for the caretakers, I would say. And if I had to say one thing about the process that I really would change, there are people that we have, like deinstitutionalization is wonderful. We don't want people institutionalized. We want them in the community. We want them well as much as possible. But there still are some people in the system, and it's a very small amount, but they still have a need that really cannot function outside of an institutional environment. They're too acute for a group home. They're too acute for some of the other structured programs that we have set up. And those people sort of end up pushing the limits of this constitutionally, I think. They end up being really long-term visitors, shall we say. And they're really, especially in this area, we just have so much of a population and so much of a need. It would be great if we had some, sort of higher care group home for those folks, so that they didn't get left behind. Because it's great to say that everybody needs to be in the community, and that's absolutely true as much as we can get it, but we also can't forget that we have other vulnerable populations that need assistance. And
well, I appreciate that, and it makes a lot of sense. And I'm going to go ahead and throw out a word. Have you ever heard of National Alliance of Mental Illness of Northern Virginia? Okay, so I serve as liaison for them. I used to be a board member. So anybody watching this, NAMI Northern Virginia, I'm a huge fan. A lot of times I'll get calls from clients or potential clients or family members, and they're like, I don't know what to do. Go to NAMI Nova. That's another resource. That being said, is there any other resources that you would suggest, maybe a website or maybe just go into Merrifield's website or anything like that you can think off the top of your head? And if you can't, then I can get it from you later and we can put it in the show notes.
Yeah, no, like I said, that Fairfax County is the only county that offers a county attorney position for that role. So it really is a little bit difficult to find attorneys who specialize in this type of law. And there's not really a ton of self-help. We do have a booklet that they give you at Merrifield that's really helpful in terms, it's just like a little booklet. It explains the hearing process, and it also has a place where you can write in the back important names and information. So if you're here in Fairfax County, I might have a copy of that I can get to you, but.
Do you know if it's digitally available?
I don't believe it's digitally available.
Okay, at some point I'll steal that from you, and then I'll try to figure out a way to get up on the web. So yeah.
Yeah, absolutely. Yeah. But they have them at Merrifield too. So if you end up there, you should get a copy. And if you don't, say, hey, can I please?
Yeah, absolutely.
A copy of this booklet that explains, and you can always give my office a call, and I can help you out anyway.
What's your phone number?
I forgot. I'm the Speakeasy Law Firm. You have to know someone to get to me. 703-220-5436, and I will look forward to hearing from you guys.
Okay. Well, again, thank you, Maggy Vaughn, for taking some time to talk to me and coming on the podcast. And I really, the reason I asked you was because I know that you get a very specialized skill set. It's very, unfortunately, very relevant to today, and unfortunately, but also fortunately, because now we're having these discussions in more open format, and I think people are willing to think about things differently. So I appreciate your work. I know you're doing a lot of adoption as well. What other things, just quickly tell us, do a little bit of self-advertising. What else are you doing right now, and how else could people get in touch with you if they need to, besides just calling you?
Really, I think I do have what I call a child-based practice. I do child advocacy work, adoption, and then this mental health thing I sort of stumbled on. I actually came to the process as a family member of someone who needed some help before I even took the position. So that's, if you need an adoption or you have a family member in crisis, give me a call and I'll be happy to help.
And I may recruit you to the NAMI board at some point too. So I know you got a ton of stuff.
I would love that. I love talking.
We'll talk. We'll definitely talk off air. But again, guys, thanks for joining Abrenio Law podcast. I'm James Abrenio. If you found this useful, make sure to subscribe to our YouTube channel. Share the video too. I want to make sure that people are watching it, and people beat down on social media, but it's a way that information gets shared, and it's such easy with a click of the button and retweet or whatever. If you found this useful, I'm sure that somebody else in your family and your friends and your networks, maybe somebody you don't know that just happened to friend you, will find useful. So again, Maggy, thank you so much. And I'll talk to you soon. And hopefully I set this up to where it's actually recorded it and we haven't wasted an hour. So I thank you so much. Okay. And I'll give you a call in just a moment, but let me see if I can get this off.
Absolutely. Have a great day. Thanks again.
Thank you.